Members, we have a quorum. I call the meeting to order. Information paper issued since the last meeting. CB bracket 41386/16 bracket 01. Is an information paper entitled Judiciary's proposed removal of payment collection functions of magistrates' courts for fixed penalty in respect of traffic contraventions not involving court proceedings provided by the Transport and Housing Bureau and Judiciary Administration. It means that the court will no longer deal with it. It will be the post office and the government that will deal with that. Under Rule 83A of the Rules of Procedure, I would like to remind members that if there is any direct or indirect pecuniary interest between yourself and the item under discussion, please disclose the nature of the interest before you speak. Item 2. Progress of work of the Inter-departmental Working Group on Gender Recognition. It's paper number CB bracket 41386/16 bracket 02. Administration's paper on progress of the work of Inter-departmental Working Group on Gender Recognition, and there is also a consultation paper on gender recognition by Inter-departmental Working Group on Gender Recognition. I will now ask Ms. Michelle Ainsworth, Secretary of the Working Group, before I ask members to answer questions.
Welcome. Yeah, it's now come to your turn, Ms. Michelle Ainsworth. We would like you to give us a brief introduction of the consultation paper and the ideas. Thank you, Ms. Ainsworth.
Thank you, Chairman. I'm pleased to have this opportunity to brief members on the progress to date of the work of the Inter-departmental Working Group on Gender Recognition. I'd like to cover 4 areas in brief in this introduction. First of all, the background to the establishment of the IWG. Secondly, an overview of the IWG's consultation paper. Thirdly, the next stage of the IWG's work. And fourthly, to reiterate some key points. With regard to the background, the IWG was set up in January 2014 to consider legislation and incidental administrative measures that may be required to protect the rights of transsexual persons in Hong Kong in all legal contexts, and to make such recommendations for reform as may be appropriate. The IWG's study is divided into 2 parts, covering, firstly, the need to establish a gender recognition scheme, if any, and the contents of such a scheme. And secondly, post-recognition issues which may arise in consequence of legal gender recognition should a gender recognition scheme be introduced. The IWG was established in response to the observations made by the Court of Final Appeal in W and against Registrar of Marriages, which is known as W's case. And I would like to add that the study of the IWG is confined to the problems facing transsexual or transgender persons. Other issues such as same-sex marriage, civil partnership, and discrimination against sexual minorities are outside the scope of the IWG's study. With regard to the consultation paper, which is entitled Part 1, Gender Recognition, on 23rd of June 2017, the IWG released its consultation paper on the first part of its study to seek the views of the public on issues concerning legal gender recognition, including whether a gender recognition scheme should be established in Hong Kong, and if so, the possible criteria and procedure for gender recognition. The consultation paper is accessible online at the IWG's website, and the executive consultation paper is attached to the panel paper for members' reference. The consultation period runs until 31st of October 2017. With regard to the current situation in Hong Kong, legal gender recognition generally refers to the official recognition of a person's gender identity, their self-perception of being male or female in law, as reflected in public registries and key identification documents. It means that in the eyes of the law, a person is seen to be of his or her acquired gender as opposed to the gender that he or she was assigned at birth. There is currently no legislation in Hong Kong which provides for the recognition of the reassigned, acquired or preferred gender of a person for all legal purposes. In certain circumstances, a change of gender is recognized in Hong Kong, where the issue is one of identification rather than legal status, and a transsexual person who has undergone full sex reassignment surgery, also known as SRS or GRS, which involves the removal of the original genital organs and construction of some form of genital organs of the opposite sex, may apply for a change in the sex entry on their Hong Kong ID cards, and if successful will be issued with a replacement Hong Kong ID card reflecting their reassigned gender. In W's case, the Court of Final Appeal ruled that a transsexual person who had undergone full SRS should be entitled to marry a person of the sex opposite to his or her reassigned gender. While the focus of W's case was on the law of marriage, the Court of Final Appeal also observed that the government should consider how to address problems facing transsexual persons in all areas of the law by drawing reference to overseas law and practice, such as the United Kingdom's Gender Recognition Act 2004. The scope of the IWG study, in the first part of its study, the IWG has been looking at the condition known as gender identity disorder or gender dysphoria, and has been carrying out a comparative study of the legislation, schemes and case law on gender recognition in over 100 overseas jurisdictions and the standards of international bodies, and has also been examining issues relating to the operation of a gender recognition scheme if one were to be established in Hong Kong. The IWG study has found that there is no single uniform approach around the world to the type of scheme, the requirements and the procedures for gender recognition, and the issues involved are complicated and controversial. On the one hand, there are medical, social and legal issues at stake for those diagnosed as having gender dysphoria which need to be tackled. On the other hand, some groups and individuals have expressed concern about the impact of possible legislation in this area and the wider consequences for the community of legal recognition of gender change. The major issues on which the IWG is now consulting the public include: firstly, whether a gender recognition scheme should be established in Hong Kong. Secondly, the criteria for determining whether a person is eligible for gender recognition. This may include, among others, medical requirements, residential requirements, minimum age, marital status, and a number of years the person has lived in the reassigned, acquired, or preferred gender. And thirdly, the procedure for gender recognition, including evidential requirements, what type of authority should be given the power to determine applications for gender recognition, and whether foreign gender recognition decisions should be recognized. In view of the complexity of the issues and the different approaches adopted by different jurisdictions around the world, the IWG is maintaining an open mind and has not yet arrived at any confirmed views or position on how these issues should be addressed. We hope that this public consultation exercise may facilitate a rational, informed and objective discussion in the community. With regard to the next stage of the IWG's work, after studying the results of the public consultation, the IWG will proceed to the second part of the study concerning the impact of gender recognition on existing laws and practice in the event that a gender recognition scheme is to be established in Hong Kong. As part of this study, the IWG will review all existing legislative provisions and administrative measures in Hong Kong which may be affected by legal gender recognition, so that any required legislative or procedural reform may be followed up by the government. The IWG will continue to consult widely in the course of its work before finalising its recommendations to the government. Thank you once again for the opportunity to brief the panel. In concluding the presentation, I'd just like to reiterate the following key points. Firstly, we recognise that the subject of gender recognition involves important legal, medical, social and human rights issues which are complicated and controversial and may have wide-ranging policy implications. Secondly, it's evident from the research presented in the IWG's consultation paper that there is no single uniform approach around the world to the procedure for legal gender recognition and the complex issues that it raises. Thirdly, the consultation paper published by the IWG seeks the views of the community on a number of issues concerning legal gender recognition, including whether a gender recognition scheme should be established in Hong Kong, and if so, the contents of the scheme. And fourthly, given the controversial nature of the issues involved, the IWG maintains an open mind and does not have any preferred position at this moment. Accordingly, the consultation paper seeks to discuss the relevant issues as objectively and comprehensively as possible, so as to promote informed debate within the community. In deciding the way forward on its recommendations to the government, the IWG will carefully analyse and take into account, as appropriate, the views received from the public during the consultation exercise. Thank you, Chairman.
Okay. Thank you, Ms. Ainsworth.
Well, I think I'll open the floor for questions from members who would like to ask questions, please. Anyone? Mr. Holden Chow and Mr. Ray Chan. We have 2 members waiting, so each will be given 4 minutes. And I will also follow the members in the order to speak. Mr. Holden Chow first. Thank you, Madam Chair. I thank the Department of Justice and the IWG members for their efforts on preparing the consultation paper to facilitate the discussion of establishing a gender recognition scheme. I must say that through this meeting, or through subsequent meetings in which we'll be hearing from the public their views and their concerns on, first, whether we should set up a gender recognition scheme, and second, if it is to be set up, the procedure for setting up a scheme. We hope that through this panel meeting and the subsequent consultation exercise, we'll know more the views of the public. I have a question. First, I understand that in the government's consultation paper, it is said that apart from establishing a gender recognition scheme to deal with the existing issues, administrative measures can also be implemented. Say, for a transsexual, if we adopt administrative measures to fully alter the gender on the person's identity card, we can already recognize the gender of the person. So by implementing this administrative measure, can we already tackle the issue? And that's the first question. Second question, when it comes to the gender recognition scheme, assuming that such a scheme will be established, to put it simply, on how we should recognize somebody's gender, well, because the public watching the webcast may not quite understand the issue. So to put it more simply, let's say if somebody wishes to go through a sexual reassignment surgery, we understand that medical surgery may be involved. And if that person undergoes full SRS and it comes with proof that such an operation has been done, and then through administrative measure, namely altering the gender on the ID card, we will be able to fulfill the purpose. So if we have a gender recognition scheme in the future, should we require proof of the SRS as cogent evidence to prove that the operation has been done? Because there is a concern that if there is no proof of this medical procedure being done, then, say, a person may biologically be a man, but he might think that he is a woman. And then, if no proof is required, it may be confusing for others and it may be controversial. So on this point, my question is this. What is the view of the administration or the IWG, and whether, as I mentioned just now, it will be simpler to tackle this issue through the arrangement of a full SRS followed by recognition of the person's gender to avoid controversies? Ms. Ainsworth.
Well, in fact, as is pointed out in the paper, the IWG at this point has no decided view on any of the issues that are presented within the paper. And
okay, Ms. Ainsworth, sorry, can you speak closer to the microphone?
Sorry. The IWG at this point has no confirmed view on the various issues raised, including issues such as the type of criteria, whether sex reassignment surgery will be required, the extent to which evidence of that would be required. These are all issues on which the IWG is seeking the views of the public at this stage. With regard to the other question about administrative measures and the extent to which that would satisfy the requirements, again, that is an issue which is discussed in the paper. We're seeking the views of the public. We would need to explore at a later date whether simply administrative measures can cover the purpose of the study, which is to find how the position of transsexual and transgender people can be satisfied for all legal purposes. It would appear that there are a number of post-recognition issues where their legal situation would need to be explored. So whether administrative measures could cover that is at this stage to still be studied.
Okay. 跟住係啊
Next, Mr. Ray Chen. Thank you, Madam Chair. We have this consultation paper on gender recognition, but this is just part one. We have waited for a long time. We have waited for 3 years. Since 2014, when the IWG was set up, there was an undertaking that within 2 years, the first consultation paper would be submitted. And then it failed, and then the other undertaking was to submit the paper in the end of 2016. Again, it failed, and then the last undertaking was made that the paper would be submitted in the first quarter of 2017. And I asked the Chief Secretary for Administration last time. In the end, this paper was published in June this year. According to the CS, the more the issue was explored, the more issues arose. And you also need to draw reference from over 100 jurisdictions. But many people find the wait too long. I don't know whether the administration noted this piece of news on the 8th of July. A transgender person jumped off the bridge in the East Rail Station in Taiwan, and according to the social media account, he failed to be recognized and he faced discrimination. So this is just the first stage of the administration's work. I want to know for the whole procedure, how long are we talking about until we go through the legislative procedure? It may take 8 to 10 years. I don't think this is the first case. I don't think this will be last either. I understand that the legislation takes time, but I hope that the administration can explain very clearly to transsexuals and transgenders and those who are concerned about this issue when this will be completed. And during the time between determining whether to set up any legislation and the enactment of the legislation, whether anything can be done. Because it seems to be very prudent, carefully worded, that there is no preconceived stance or views of the IWG. Well, Professor Joan, you have been joining the group for some time. I understand that you would feel the difficulties of these people. Let's say for somebody who has adopted the acquired gender, when the person goes to a bank, he or she would be addressed by the other gender instead of calling the person sir or madam. The other way around should apply, and this may even cost them some trouble. And when it comes to dealing with the police, we have the body search, detention, all these issues arising. So meanwhile, I wonder if the administration can adopt some procedures so as to make sure they have dignity.
With regard to the timetable question, at this stage, because this is just a consultation paper, we will of course need time to analyse the responses and to then consider the next stage. So it's too early at this stage to give any indication of when the study will be completed. With regard to the issue of your second point about the complexity of the issue and
short-term measures.
Well, I imagine that the government will be carefully looking at the terms of the consultation paper. I can't comment. I'm only here representing the IWG, so I presume that the government will be carefully looking into the issues that have been raised in the paper, and any necessary or possible measures may be looked at and may be studied as to whether they could be looked at in the interim.
I understand that I can't have a debate here with Ms. Ainsworth. I do believe that those who are concerned with rights of transgender might be very anxious, and they are very disappointed. This is the first step. There is a consultation paper. Is it the case that it's estimated it will take 8 to 10 years, and you can't even answer that? When it comes to short and medium term measures, I believe that we will have to wait till after the consultation period. Maybe I will state my stance again. Perhaps there can be short to medium term measure put in place, because we're expected to wait for 8 to 10 years. This group of people will be living under tremendous measure. There should be some assistance or support given to them. And I do hope that this panel chairperson to hold a public consultation on the consultation period. However, the consultation period ends at the end of October. I wonder if it will be too close to the deadline if we wait till the meeting in October. Perhaps at the end of September we can hold a public hearing to invite people to come to give their comments.
You would like to take the question, 張達明先生係。
或者我都講少少我自己一啲。
Perhaps I will say my piece. I'm a member of the IWG. I can't answer everything on behalf of the working group. However, I myself am anxious as well. And I do understand that for a lot of transgender people, they are anxious as well. They would like to see some kind of reform as soon as possible. What I can say is that I do hope that we will be able to expedite our work in the working group. But I'm afraid I can't give you a concrete timetable. Maybe not a concrete timetable, but can you give an estimate how many years it would take? It will be difficult for me. I'm a member of the working group. Mr. Chan, you need to understand that I'm only one member of the working group. It's difficult for me to speak on the group's behalf. We don't want to see any tragedy happening. But I'd like to say one thing. Just now, Mr. Chen talked about short-term measures and then cited a number of examples. My personal view is that there needs not be a wait for the work of the consultation group to be done, because sometimes these issues may involve discrimination. The scope of the terms of reference of the working group, as stated, will not deal with anti-discrimination issues. Yes, that may not be the terms of reference of the working group, but something needs to be done in the discrimination laws. The process of establishing the scheme might be put in place, but it will not address difficulties faced by transgender people. Yes, you have made it very clear that you will not deal with same-sex marriage, discrimination, or civil partnership, but you need to do something. Well, as you have said it yourself, that you realize that this is not under the terms of reference of the working group, and I'm here in the capacity of a member. There may be some other departments that will take that up. Well, that will be outside my capacity as a member of the working group. Your time's up. The second part is whether there will be a public hearing. Perhaps I'll hear from other members as well. Dr. Fernando Joan, I concur. So there aren't any objections, right? Before the end of the consultation period, we will have to find a date and a venue. I think it will be about end of September or early October. As soon as we find a date, and we will inform you and make arrangements to invite deputations and individuals to come. Next, Mr. Alvin Young. Well, I express a concern, just like Mr. Ray Chen. The Court of Final Appeal gave the judgment in May 2015, and the working group can't give us a timetable. I hope that the Department of Justice will do something about legislating for it. There is a huge legal vacuum before we have legislative amendments. The direction of consultation. The Court of Final Appeal in the case said that the order should cover the reference of someone who's undergone gender reassignment surgery from male to female. When the administration considers the criteria under Article 37 as well as 19 subsection 2 of BORO, they need to consider this. Those who have undergone the surgery, those who are not suitable or unwilling to go through the gender reassignment surgery. I do believe that they all meet the criterion set down by the Court of Final Appeal. I'd like to know the view of the working group. Ms. Ainsworth.
Again, those are actually issues that we are covering in the issues to be consulted on. We have looked in the content of the consultation paper. We've actually looked at the issues from not just the perspective of persons who've gone through same-sex reassignment surgery, but also more generally persons who, for one reason or another, are not able to do the surgery, for example. So the consultation paper is actually broader in its scope than just transsexual persons. It also covers and asks about the position of transgender persons. So we're hoping to get some response from the public on their views on that.
Mm-hmm. Yeah. Okay.
No follow-up. Next, Dr. Fernando Joan. As Mr. Alvin Young said, well, there is a judgment given by the Court of Final Appeal. Even though the law remains unchanged, those who have undergone gender reassignment surgery, if they get married, their marriage will be recognized. The law needs to be changed as soon as possible. That's the duty of the administration. There is this working group, and then there is the consultation paper. But they don't give us a timetable for legislation. And legislation against discrimination against people with gender identification problems is nowhere to be seen. We are very disappointed. We expect more concrete and specific measures, and we urge the administration to amend the law as soon as possible. I thank the working group. We all work on a voluntary basis. It's a kind of contribution to society. However, our duty is squarely on the shoulders of the administration. They can't just shift the work to a group of voluntary workers and think that their work is done. The court has made it very clear that the law should be changed. Will there be a timetable, or they just want to wait and see? Well, as you know, Madam Chair, that there are many many meetings going on at the same time. So any timetable?
I can simply reiterate what I've said earlier, that at this stage, until the consultation phase has been completed, I believe that it's too early to give an indication of a timetable.
Then it's very unfortunate. Because there is a court case, the court has asked for something to be done. So please do not try to avoid doing anything. Yes, once the law is changed, it can't be changed back. Perhaps we can hold a public hearing in LegCo to collect views, and I hope the working group will, as soon as possible, give us a report and really ask the administration to give a timetable for your recommendations to be implemented. Lastly, it's my turn. To be fair, the administration has introduced amendments to the marriage ordinance pursuant to the W's case. I am the Bills Committee member, so is Mr. Ray Chan. There has been a discussion for over a year. However, in the end, the proposal was voted down by majority. It was legal adaptation pursuant to W's case. The court said that the LegCo should amend the law within 1 year. Otherwise, they would use common law, referring to court decisions made. Perhaps it is very controversial to amend the marriage ordinance. Well, I just want to say that they have actually done something. Some other members mentioned this. If it's a person who says that psychologically, say, it's the body of a woman, but with the mind of a man. The person does not want to go through the surgery, perhaps because of financial reasons. In overseas jurisdictions, all I know is about news reports. Well, some people think a man. Some people think that. Some people think that, a woman has entered a man's toilet. So when it comes to gender recognition, well, it's a social issue as well. Because if it's not clear whether one is a male or female, and that person enters a female changing room, then it will be very confusing. And it will be embarrassing as well. Well, even with the court decision on W's case, legislative amendment is difficult. What about other issues? Say, for example, someone cannot afford the surgery when the person has passed all the other tests. Would there be some administrative measures to help people like that?
In Hong Kong, actually, the hospital authority provides very good and comprehensive
You mean
service.
public hospital?
Yes.
Okay.
So in fact, expense normally, I think, in Hong Kong would not be an issue.
Okay. Okay.
Would you like to? Yeah.
好，張先生係。
都好快啦。其實頭先
Mr. Zhang. Very briefly, to respond to Madam Chair's points, in fact, they are set out in our consultation paper. In fact, in our paper, we set out the opposing views of various issues. For example, whether the SRS is a necessity. And we also set out the opposing views. And we'll give this a thought, but we do not have any preconceived stance. Well, I understand that there are some gender-friendly toilets. But I wonder whether the wording should be, unisex toilets, because gender-friendly doesn't really refer to the real scenario, because it's for somebody who's not a man or a woman, or that if a person goes to that toilet, the person doesn't mind whether it's for gents or for ladies. So it's a matter of choice. As for the wording, gender-friendly toilet, I don't think the title is appropriate. So that's my suggestion. The other point is this. Now, in other jurisdictions, say, for example, a number of states in the United States, there are different approaches to the issue. And in some circumstances, the full SRS is not required. So I want to know whether there are any social problems in those states, because I'm just reading from the news. Have you conducted any in-depth research into the social issues? The person may have the appearance of a man with the mind of a woman, and then the women may feel very uneased about that, because there may be teenagers and other ladies in the changing room.
Types of issues certainly we have been looking at as we've been proceeding, but they may also be looked at in the context of the post-recognition part of the study. What we have done in our analysis of the overseas jurisdictions is to look at their legal positions. And it's very clear that there is, as you've said, different jurisdictions adopt very different approaches. Some require only self-affirmation and a declaration that a person wishes to be identified in the opposite gender. Other jurisdictions have very strict requirements, right through from hormonal treatment, same-sex reassignment, sex reassignment surgery. So in terms of the social issues, that's certainly something that the IWG will be looking at. And we hope in the course of the consultation exercise to receive views and concerns from the public on those types of issues, so that we can certainly take as much into account as we can. I should reiterate that the whole approach of the IWG in preparing this paper has been to try and provide as much comprehensive information to the public, so that the public can have a very informed view of what the issues are, both at the transsexual person's point of view and from the point of view of other groups in the community that may have concerns in this area.
Okay.
Now, my question is this. It's for the IWG. Well, there may be some figures in Hong Kong, let's say. There may be people who are unwilling to go through the SRS. The person may have gone through the psychological assessment, but then the person may not want to go through the surgery itself. And as in some other cases, because of the physical condition, the surgery is not suitable, although the person may have opted for the surgery. Under such circumstances, how do we assist them? And how do we provide support at the policy level from the government? And that's what I'd like to know, because you refer to other jurisdictions. In some jurisdictions, a declaration or affirmation would suffice. But I've heard that, in some jurisdictions, perhaps you'll hear more from the public during the public hearing, that there should be a selection of gender at the time of birth. Well, anyway, for Hong Kong, I'd like to know, apart from the legal amendment, whether there is anything administratively to help these people, so that there won't be the embarrassing situations I mentioned in the community.
Well, of course, at the moment we have the administrative measures in relation to the Hong Kong identity card. Beyond that, this is certainly something which the IWG will be looking at very closely. I can't comment on behalf of the government as to what it might do, but certainly from the point of view of the IWG study, administrative measures will be looked at as well as potential legislation.
Okay. 仲有冇?
Anyone else? Oh, yes, Mr. Eric Chung.
個問題呢，
Responding to Madam Chair's question, the IWG has also met with some experts to seek their views. In my recollection on this issue, it seems that for those with gender dysphoria, according to the experts, there are two streams. Well, some of them really resent their bodies, so they have a strong desire to change their body so as to acquire the other sex. The other stream is that those people do not resent their bodies, but they would like to acquire the other sex as a matter of identity. And that is the issue arising from whether it is necessary to have an SRS, and that's why in some jurisdiction the full SRS should not be a prerequisite. And that's their argument. Whereas in Hong Kong, in our public healthcare sector, frankly, for those approaching public hospitals, they would fall into the first category. That is, they have a strong desire for the other sex, and they would like to seek medical help to undergo SRS. But the medical procedure in Hong Kong is that they need to go through counseling, assessment, and real-life test. And only when they're found to be suitable for the surgery, upon assessment, would the public hospital conduct the surgery for them. And that's the procedure in Hong Kong. According to the local expert, the cases that he has come across, those patients have a strong desire to undergo this operation. It's actually the other way around. The doctors must conduct an assessment. Well, we have a public hearing on the next occasion, but perhaps you can get yourselves ready for this. We have heard from the news that in some jurisdictions, one person may think that he is a male today, but 2 or 3 years later, that person may want to give birth to a child, and then the appearance may be of a man, but the body remains female, and there is a very drastic change. But it's not about just an individual, because in the community, we need to distinguish between male and female for the sake of, washrooms, changing rooms, and other facilities. So I wonder if for others in the community, they would also find it problematic. Are there such cases in Hong Kong? When we discuss these issues in the consultation paper, according to experience, indeed, a reversal may take place. And that is why, when we set out views from both sides in the paper for consideration, one of the points is for the public to consider this, exactly because other jurisdictions have this experience. A certain set of criteria has to be adopted to make sure that there won't be a reverse of the decision. Say, for example, in some jurisdictions, a full SRS may be required so that you can't reverse it, but that's not the approach taken in some other jurisdictions. In this consultation paper, like we mentioned just now, we just want to provide as much information to the public as possible so that they have an informed view of the views of the comments from both sides, so that the public can have an informed debate when they give us their views. All right, so we thank the IWG for coming and explaining to us their work now. I think that the criteria is as set out in the W case, and that certain criteria must be met, and that the person must have undergone the SRS and adopted the opposite gender in real life for some time. All right, if there are no other questions from members, I think that we can further our conversation on other occasions. And if necessary, we can arrange for another meeting. Thank you.
跟住呢，就係我哋落
Next item. Measures to prevent the misuse of the legal aid system in Hong Kong and assignment of lawyers in legal aid cases. Paper LC paper number CB bracket 4 1386/1617 bracket 03 and 04. And also CB bracket 4 1386/1617 bracket 04, as well as the submissions from the Hong Kong Law Society, CB bracket 41422/1617 bracket 01 and 1419/1617 bracket 02 from the Bar Association, and also another paper, CB bracket 41427/1617 bracket 01 from the Justice Centre, Hong Kong. So perhaps I'll invite the Deputy Secretary to brief us on the measures to prevent the misuse of the legal aid system in Hong Kong and assignment of lawyers in legal aid cases. That's in paper bracket 03. Mr. Patrick Lee. This paper briefs members on the measures implemented by the Legal Aid Department to prevent the misuse of the legal aid system in Hong Kong and the assignment criteria for assigning lawyers in private practice to handle legal aid cases. Legal aid services form an integral part of the legal system and play an important role in contributing towards upholding the rule of law in Hong Kong. The policy objective is to ensure that all those who have reasonable grounds for pursuing or defending a legal action will not be denied access to justice because of a lack of means. To qualify legal aid, a person is required to satisfy both the means test and the merits test. At present, a person is provided with financial assistance under the ordinary legal aid scheme, that we have a mechanism to prevent misuse, and namely tests to ensure that only those with merits can or reasonable grounds can be provided with legal aid. The merits test will be conducted if complex legal issues are involved, and then under Section 9D of the LAO, the Legal Aid Department can also seek independent legal advice. Second point on monitoring. Legal aid certificates that covers only certain area will be extended only when there are merits of the case. Otherwise, it will be cancelled. And there is also a mechanism to prevent abuse of legal aid, which involves provision that any person seeking or receiving legal aid who knowingly makes any false statement or false representation in furnishing the information shall be guilty of an offence and liable to a fine at level 3 and imprisonment for 6 months. And anyone who believes that the person's furnished false information will subject to a revocation of the legal aid certificate, and also recovery of the cost. And according to Section 11 of the LAO, if a person repeatedly apply for legal aid and after being refused, the director may order that no consideration should be given to any future application by that person for up to a period of 3 years if his conduct amounted to an abuse. And the LAD will examine the situation and, if necessary, take follow-up actions. Altogether, in the past 3 years, 84 certificates were revoked, and 70 cases were also referred to the police for follow-up action. 8 prosecutions were initiated in the past 3 years. In terms of the merits test adopted by the Legal Aid Department, the same applies to the judicial review cases as well as civil legal aid applications. That is, according to Section 10.3 of the LAO, legal aid would only be granted to applicants who can show that the cases have reasonable grounds for conducting JR proceedings. The number of cases in the past 3 years and the total contribution paid by the applicants amounted to 4 to 5%, and the successful rate is maintained at 88%.
Section 13 states that the Director for Legal Aid may, through Legal Aid Council, act for the aided person. They may also assign any lawyers in private practice who are on the legal aid panel to selected by the aided person if he so desires, or the DLA. There is a set of criteria on the assignment of legal cases which has been endorsed by the Legal Aid Services Council. There is also a manual for legal aid practitioners issued by the Legal Aid Department. Well, unless there is a reasonable grounds, the nomination of the aided person should be taken into account. Well, if in the case that the lawyers nominated has taken on too many cases, the Legal Aid Department will request the aided person to nominate another person. Well, since 2013, the LAD has tightened up the enforcement of the limits of set for number of assignments. This covers civil and criminal cases of all categories. The department has also recently completed a review on the assignment limit. Please refer to paragraph 18. We plan in the fourth quarter of this year implement the new limit. We have also consulted the two professional bodies. As a measure to combat improper touting or championing activities, we have introduced a declaration system for legal aid applications in September 2013 after consulting the LASC and the two legal professional bodies. The system seeks to ensure nominations of lawyers that are made out of the aided person's own free will and they have not agreed to share any damages, property or costs. The Legal Aid Department has also established a system to monitor the performance of assigned lawyers. There is a departmental monitoring committee chaired by the Director for Legal Aid, which will evaluate the performance of assigned lawyers. Well, we have altogether issued 6 warning letters, and in the disciplinary register we have also made 32 entries. We, through different channels, step up publicity and educational efforts. Every year, the Legal Aid Department will organize different activities to enhance understanding of our services. We will continue our monitoring work and enhance publicity and public education. I myself and the Director for Legal Aid will be happy to answer questions. Thank you. I will first ask Mr. Nicholas Apiri, representative of the Bar Association, to speak.
Thank you very much, Madam Chairman. Mr. Barretto sends his apologies for not being here today. The question has arisen because of alleged misuse of the legal aid system. I can summarise that the Bar Association is very satisfied overall with the way in which the legal aid prevents misuse. But what you should realise is that in many cases legal aid is only in fact the second stage of a person's consultation, because more and more persons seek pro bono advice first before going along to the legal aid department. So you can see in due course, when we look at the figures, they have some very good results. So the point that we want to make so far as the judicial review cases are concerned is that the Legal Aid Department often is not involved at all in the preparation of the judicial review case, because the Legal Aid Department often takes the view that legal aid should only be granted when leave has already been given by a judge. So consequently, this is the system that has been adopted, and that you can see from the numbers the effectiveness of legal aid in the judicial review cases has been quite high, and that really reflects also on the work of the independent lawyers who work pro bono to obtain leave for would-be applicants. So there is very little abuse. I think the Legal Aid Department has been very good in recognising that judicial review applications are at the cutting edge of the law. They involve your rights and my rights, and it's an important example of how funds, government funds, are used in the public interest, and we support that process. The complaint, I think, arises after a certain retired judge's comments were made to the FCC, but this arises not because of the fault of the Legal Aid Department. It arises because the Immigration Department did not get to grips with large numbers of immigrants, I think 10,000 immigrants who were not properly processed to see whether or not they could stay in Hong Kong. So there was an upsurge in numbers, and you can see that in 2014 there were 98 applications, 2015 248 applications, and in 2016 144. Far from there being abuse, you can see the grant rate has dropped dramatically from 53% to 6.25%, and purely on a numerical basis, Mr. Thomas Kwong's department can hardly be criticised. In fact, the criticism might go the other way, because the rapid drop might, in the opinion of this committee, merit some further inquiry. Again, you can see in 2014 other judicial review cases there was a grant rate of 13%. That's dropped to 6.15% in 2016. So that although the total number of applications have gone up, this really is an inappropriate criticism. And the Legal Aid Department obviously have, once they've granted cases, these are throughput, and so there's been a very slight increase in the percentage of the legal aid budget to cover those cases. It's up from 4 to 5%. We would like to comment and favourably. The legal aid success rate is very high. PI cases, very few fail, mostly 90% win. Medical and dental, the case average is about 71% over the last 3 years, and miscellaneous is about 56%. And these are very reasonable figures, bearing in mind the relatively low threshold for grant of legal aid set in Section 10.3. So the only figures we don't really know about is legal aid appeals, because at the moment there are no open figures which are shown to the public about the reasons for grant, withdrawal or otherwise. So we would ask this panel to get the Home Affairs Department and the Legal Aid Department to look into the cases where there's been a lot of preparation pro bono, and consider amending the terms of the guidance notes given to solicitors and barristers when they take on legal aid certificates, because the legal aid certificate cannot cover currently retrospective work. And this is particularly so in medical and dental cases. Those are things that I'm involved in currently. A lot of work has to be put in, often where a legal aid certificate is initially refused. There's a master's appeal and so forth, so that that process is not covered at all in the costing of this system. I cannot stress too highly that many lawyers take, and we have some lawyers here sitting in the panel, taken 7 years or more to qualify, and they expect to be paid on a proper basis, and our system should not be limping along on pro bono basis. When you go to a public hospital, you don't expect to be seen by a pro bono person. You expect to be seen by and received by an experienced emergency department team. And it's a bit unfortunate that we have this great emphasis here on currently on pro bono. So we would, in paragraph 5, conclude that a flexible system of retroactive payment for professional work is reasonable and necessary. We also think that the legal aid system needs to be kept up to date to ensure that there's continuing access to justice and the benefits of our common law-based system continues for the next generation of Hong Kong citizens. The second aspect we want to look at is assignment of lawyers. I've been in practice for 40 years here, and there's been repeated criticism and allegations made, largely unfounded, and the ICAC has been involved, I think, at least on 3 occasions, looking at the way the cases are allocated. The Bar Association and I think the Law Society don't think that altering the limits on cases or payment is not the correct way forward, and the Legal Aid Services Council and neither the Legal Aid Services Council nor the Home Affairs Bureau has actually consulted. If you look at the words in their paper, they actually say, we have informed them. So we think that the Legal Aid Department and its supervisory bodies should be looking at the quality of work, and cutting crude across the board limits is not a proper response, and it's not very cost effective, and we think that they should perhaps instead be looking at block allocation of legal aid in regular cases, and those block allocations are conducted in other countries, and therefore this would save the Legal Aid Department and the legal aid system considerably, because they will be able to set a standard fee. So we don't really know what the factual basis is for the adjustment. Is it just a knee-jerk reaction to a public criticism, or assumed public criticism, and they've just said, oh well, we better cut the numbers? We just don't know whether if there's a logical basis on which just to adjust numbers. The other point which the Home Affairs Bureau is not aware of is that in fact we now have and have had for many years class actions. Mr. Kwong will be able to confirm that, perhaps not over such a long memory period of mine, but they have been assigning cases on a class basis to individual law firms and barristers for years. Thalidomide cases, HIV/AIDS, blood transfusion cases, SARS more recently, Shekong disaster cases, KMB bus accident at Sham Cheng flyover, Seapel Marco fire, Top 1 karaoke fire, and in all those cases we know that a large number of cases have been assigned to 1 or 2 firms to handle, and barristers to handle those cases, and it makes sense to do so. In those cases, I know personally that the High Court has given class action directions in the past, so the Home Affairs Department are just not aware of how this system has operated flexibly, and this is a major omission in their discussion in paragraph 19. Further, there's no account taken of the specialist nature of the legal aid practice in certain areas of practice. And in those areas, the Home Affairs Department must be careful not to discourage solicitors and barristers from taking those cases because of the legal aid delay in taxation. Mr. Kwong can give better examples than I can, but I've recently been approached as to whether I would waive my fee in a legal aid taxation, which was held 16 years. The case I worked on was 16 years ago.
Okay, Mr. Berry.
So,
sorry, I may only give you 3 minutes,
That's fine.
so that the other members of the panel may follow your opinions, as well as we can have more time to question the Department of Legal Aid.
yes.
Thank you.
Can I just go quickly on to the Departmental Monitoring Committee? This is the first time we've heard about it, and if barristers and solicitors are to be taken off the list, then they ought to be allowed a hearing and dealt with as the same way as contractors under the building ordinance. It's not very good news to hear that lawyers are not being treated fairly and openly. I don't need to say any more about that, but that should be reconsidered. Section 9 opinions I'd like to move on to, and I think this is a very important matter. A Section 9 opinion is given, and they want to change the rules so that the counsel who's given an earlier favourable opinion will not be assigned to handle the case if legal aid is subsequently granted. In my own practical experience, this rather reflects badly on the profession without due consideration. It will also duplicate work, particularly in medical negligence cases that I work in, and that will also increase delays, very considerable delays, if the case has to be considered by another barrister later. And this happens in masters' appeals and also where senior counsels advise possibly. So we think that this is inappropriate, and if they have a question about the validity of a Section 9 opinion, then they can always ask another barrister to review it. So we would invite this panel to reject that proposal. Madam Chairman, you've kindly written to us to say that you will hold a hearing after the summer recess as to the financial eligibility problem, and no doubt the departments concerned will be able to respond to our quite serious criticisms as to what has happened hitherto since 2000. The wrong numbers are being used, basically. Barristers don't cost their services in relation to the cost of charcoal or kerosene in public housing estates, and those are the CPI figures that they're using. That is all we wish to say, Madam Chairman.
Okay, thank you, Mr. Perry. 而家咧就係委員發問嘅時間。
Well, questions from members. We have Mr. Ted Hui and Mr. Elvin Yang. Any others?
係何君堯議員同埋我。首先
Dr. Junius Ho and myself, Mr. Ted Hui. 4 minutes. Questions and answers included. Please be brief. Paragraph 10 of the government's paper referred to abuse of legal aid, and Regulation 11 of the LAR provides that the Director of Legal Aid may order that the person must not submit any future application for up to 3 years. But my concern on the abuse is not about hiding one's income or assets. On the contrary, there are those in the community who are, say, very interested in legal issues and who would like to launch judicial challenges against the government very often. And I understand that the Legal Aid Department would cite Regulation 11 of the LAR to forbid the person from submitting application for up to 3 years. So let's say if a litigant files a judicial review, or file many judicial reviews, it may increase costs on your part. But on the other hand, if you ban this person from seeking judicial review, you are depriving the person of the right to seek justice. And this is exactly my concern. Is it really the case that the public is abusing the system of legal aid, or is it that the administration is abusing its discretionary power under Regulation 11 by turning people away from legal aid? It is a major concern, especially when we see that the administration is taking the lead to resolve political issues through legal means. Then, similarly, members of the public would like to resolve the issues through the same mechanism, but if they would be prevented from making applications, they would be put at a disadvantageous position. So how can you reassure us that you are not abusing the system? Mr. Kwong, please speak into the microphone. Thank you, Madam Chair, and thank you, Mr. Hui, for your questions. First, I think that perhaps the recent case has attracted wide media coverage, but I don't think it's appropriate to comment on any individual case because the case may soon be in sub judice. Coming back to the legal aid regulation, Regulation 11 clearly stipulates that if the same applicant has repeatedly applied for legal aid for 2 times on the same subject or 4 times on different subjects, then it may amount to abuse of legal aid, and the director may order that no future application by that person should be entertained for up to 3 years. But I think that there is no concern whether the legal aid department is abusing the system, because the decision of the director may be appealed against. So the registrar of the High Court ultimately makes a final decision. So if you're concerned about the abuse by the legal aid department, well, first of all, I'm sorry to say that I cannot divulge any information in relation to this case. We have grounds for making that decision. But I just want to point out that the law clearly provides an appeal mechanism. And from experience, we had cases being appealed or judicially challenged, and the case was brought to the registrar of the High Court. Well, to save time, let's say if the person wishes to challenge the decision of the Director of Legal Aid, the person still needs to fork out money for the purpose. And about the cases that you mentioned, any figures you can cite? For cases of this nature, even if the director's decision is to be challenged, the applicant may still apply for legal aid and will seek independent legal advice from a counsel. So if we maintain that the director's decision is right, we can seek independent legal advice. So this is to lay members' concerns. Second member, Mr. Alvin Young. Madam Chair, I'm referring to the figures in paragraph 7 of the paper, and I'd like the director to elucidate on these figures. Under civil legal aid, appeals against DLA's decisions, we have 2 sets of figures, appeals heard and appeals allowed. We can see that for appeals allowed, the percentage is very low comparing to the appeals heard. So on civil legal aid, I'd like to have more information. Do you have a breakdown of the appeals heard of, say, judicial review cases and other civil cases which are not JRs? And also, for appeals allowed, the similar breakdown so that we have better knowledge of that. Mr. Kwong. Thank you, Madam Chair. Thank you, member, for the question. I do not have the figures at hand. That is to say, a breakdown of the different cases, different categories of cases. But as I understand, for JR cases, there aren't many of them. There aren't many appeals heard of JR. The same applies to appeals allowed, but I'll supplement this information after the meeting. Mr. Young, well, I am not in a hurry to get those figures here as long as the director will give us the figure after the meeting. Now, as for appeals heard involving JRs, I mentioned that for appeals allowed, the percentage is not overwhelming, and that's what the director suggests, right? So, in relation to the allegation of abuse of legal aid in recent years, I don't think that the argument holds water. On the contrary, Madam Chair, I think that legal aid is not sufficient. But of course, it hasn't to do with the director. It has to do with the administration's policy. As pointed out by the Hong Kong Bar Association, well, many related proceedings are not covered. For example, cases involving claims from small flat owners. Since we have government officials from the Home Affairs Bureau and the Home Affairs Department here, I'd like to bring this view to your attention. I think that we should revamp the legal aid system because we do not have class action and other issues. We are out of date and we are providing the only means for the public to access justice, and that is the legal aid. But Hong Kong is really lagging behind. And that's the comment I wish to make. Anything to add? If not, then next member. Anything? No? Mr. Junius Ho. Madam Chair, I have a question for the Director. In paragraph 11, you cited 3 sets of figures from 2014 to 2016. Well, I see the figures on the rise, including the total contribution. Can you tell us? Well, if you have figures available at hand, then please tell us. Otherwise, please supplement the information. In 2016-17, we spent $36.3 million on cases involving JR. How many cases of JR are we referring to? What about applicants making repeated applications? Can you give us any information for reference? Of course, I understand that some cases may be sensitive, they may be in sub judice, but at least we would like to have a general picture. Because $36.3 million accounting for 5% or so of the total legal aid costs, I'd like to know how many cases were involved. Because I understand that we have 120 to 150 JR cases on average per year, depending on the circumstances. And I'd like to know, for the $36.3 million on JR cases, how many are they? Second question, I'd like to refer to Annex B of the paper. There is a table under heading B, the total number of civil assignments to top 10 counsel. How many of them were JR cases? Because just now the 2 members are concerned about JR cases. I'd like to follow up on those points. If you have information at hand, do tell us. Otherwise, supplement the information later. I don't have any information at hand about the breakdown of the $36.3 million spent in 2016-17. How many JR cases were involved. So I may need to supplement the information later. Thank you, Director. The other point is this. Looking at the present figures, 5% of the total legal aid costs of the year. Let's not forget that for JR cases, 5% is not really a small amount, because we're talking about 20,000 odd cases approved, amounting to 52% or 8,000 cases. So, out of the 8,000 cases, the JR cases only amounted to some 120. I wonder if the 5% is reasonable. And also, we have 7.2 million people in Hong Kong. Is it really just to spend 5% of the total legal aid cost per capita on JR cases? And also comparing to Southeast Asian countries and other Asian countries, I want to know whether the sum is reasonable or not.
無 cap 係社會裏邊有需要，我哋就俾。但係慣常嚟講，你批出嘅錢都有成7億幾，唔計個 administrative 同埋 staff 嘅嗰個。
You have approved about $700 million, excluding payroll. So is there a limit? I know that there is none, but can you tell me? Director or the DS? Yes, that is right. We don't put a cap on legal aid. But I need to supplement one point. The amount spent on costs for judicial review stands at about $36 million. But I'm talking about expenditure. About 70% of the cases are successful. As you know that, well, both sides are a government, the other side's the Department of Justice. Now it's my turn. First of all, well, we have actually asked the Secretary, Mr. Chang Tak-sing, before, and he said that there is no cap on the expenditure of legal aid. However, there is the impression in the community that there is abuse of legal aid. I think it's related to judicial review, because these cases involve works and it affects other stakeholders. When it comes to high-quality legal assistance, if members of the public is denied access to justice because of lack of means, I do think that we do need to review the situation. Well, I believe that legislators from the legal sector have done a lot of pro bono work as well. Is the legal aid department a kind of legal clinic? Perhaps you can use full-time lawyers to do the work. And that include support in cases that are currently not covered by the legal aid. Say, for example, compulsory sale, or as well as litigations involving small flat owners. There has been criticisms flying around. Well, criticisms against the legal aid department saying that they only assign cases to lawyers familiar with them. That's why Mr. Junius Ho asked about Annex B, 3, 2, and 1. So, well, for the 3 cases, how much did you give them? Perhaps 1 is an astronomical amount, 3 is a small amount. You need to show us that there is equity or fairness. As soon as I joined the electrical, a lot of lawyers asked me to ask for them. Assignment to lawyers. Well, different lawyers may have different expertise. That is the case for counsels as well, not just solicitors. I know that there are some counsels on fiat. It's a case involving the basic law. So, will the case be followed up by a solicitor and a counsel? Just like the system of public hospital. You don't have one choice only, but you can't nominate. So lawyers will be assigned a case random from a pool. Don't charge a seasonal price. Charge a reasonable price. You see, doctors working in the public sector can charge a lot more in the private sector. So they have to be properly remunerated. This will benefit both sides. Cases, whether they are civil, criminal, or judicial review, well, legal aid should be given. However, when it comes to implementation, there are strong views coming from the legal sector. Perhaps I will use my second round. You will gather your thoughts. Dr. Fernando Joan. Well, about the issue of whether legal aid is abused, in particular judicial review cases, usually JR cases involve the government. And I do believe that most of the JR cases are not successful. However, according to the director, he said that 70% of the JR cases are successful. I do believe that you would consider the facts of the case to see there is any merit and whether the chance of success is high. You say that the success rate is 70%, so it's a very good track record. And I do believe that only a small amount of JR cases are legally aided. Is it about 6%? Can you give me the figure? We want to know that the success rate of judicial cases out of the total. By then I mean the government loses the case. In the year past, that is 2016, we have calculated the success rate is about 70%. That excludes cases in which legal aid has been granted this year. I would like to say that in relation to the table, in paragraph 11, it says that in 2016 there are about 437 applications and 27 legal aid certificates granted. But it doesn't correspond with the number 437 because that is the number of applications in that year. And 27 is the number of certificates granted that year. The application for the certificate might be made the year before. So don't misunderstand this. In relation to success rate of judicial review cases, it's about 6%. 6% is the success rate. 6.2%. We do conduct merit tests, and even when it's granted, we will monitor the progress of the case. We will first obtain advice from an independent counsel before we grant an approval. Afterwards, we will continue to gather information. If we find that there is insufficient evidence, we will terminate the certificate. So in the end, the success rate is quite high. So there is no evidence showing that when it comes to judicial review cases, there is any abuse of legal aid. It accounts for about 6% of all judicial review cases. Perhaps the approval rate is quite low. You're on the conservative side. I support your work. Mr. Holden Chow. Thank you. I'd like to ask, sometime earlier, some individuals obviously abuse legal aid and they have been punished. That is, for a period of time they can't apply for legal aid. So I'd like to ask, when it comes to applicants who abuse legal aid, well, people who made repeated applications, what is the impact on you? My understanding is that you have you have a certain amount of manpower and resources. Would it be the case that you have spent time and manpower to deal with abuse cases, and as a result, some other applicants whose case have got married are affected adversely? Director. Thank you. If we issue a Regulation 11 order, we have already taken into account a number of factors. Well, an abuse may not just be about repeated applications. It also affects other things as well. When we reject an application, the person may lodge an appeal. When appeal is lodged, we will have to make arrangements for the registrar, for the High Court to hear the case. As a result, some other cases will have to be postponed, especially if in cases of frequent appeal. A lot of times, these appeals are quashed. Yes, it will pose a restraint on our resources, and there's also pressure on the registrar. If an individual deliberately abuses the system, then other cases may be affected because there is limited resources and manpower. I think everyone will notice that. Next, Ms. Elizabeth Quat. Thank you. We all know that legal aid is very important to enable access to justice. A lot of people get the impression that legal aid is abused. I believe that is because of some cases. Say the case that in which someone is penalized, that is the king of JR. This will give the impression that some people abuse the legal aid, and that actually is a fact. Some people do abuse the legal aid and abuse judicial review applications, and it hurts our society. There are a lot of figures in the paper. We learn about this for the first time. Questions are asked, but we can't answer them. Is it because of a lack of transparency? You said in your paper that you can decide whether to grant legal aid from a point of law. But what about approval criteria, transparency, reasons for granting legal aid? The public don't know about the information. Can you make more information available to enhance transparency so that the public can monitor the legal aid system to improve it?
有濫用嘅咧，希望有一個阻嚇性啦，係咪？
And to deter any abuse of the system, and also if there is no abuse, we can strive for more resources. Otherwise, well, of course, in the case of an abuse, the person may be penalized. On the other hand, there are people who really need legal aid, and if we address the issues, we can avoid any controversy. Director, thank you, Dr. Quad, for your question.
我哋其實現時都有落社區啦。
Well, at present, at the community level, we conduct talks in schools and the community to educate the public about legal aid. As to whether we can enhance publicity so that the community can more thoroughly understand. Well, Madam Chair, I want to emphasize that it's not about publicity and public education, but about making known to the public, be more transparent about the grounds for approving or rejecting a legal aid application. This should be available online so that we can monitor the department. At present, since no such information is available to the public, we don't know whether the applications or the decisions are reasonable or not. And just now you mentioned the figure, 70% success rate in 2016. What about those rates in 2015 and in previous years, back all the way back in 2012? 2015, the figure was 52%. And then 2014, 60%. That's a success rate. What about the success rate in the previous decade? Can I ask for this supplementary information later? Yes, please do so in writing. And as I pointed out just now, about the figures, 3 lawyers assigned to a certain case, etc. This is not sufficient. We need more information. 3 lawyers assigned to which 3 cases and the costs involved, because otherwise we can't have a fair assessment. Let's say if all the 3 big cases are taken up by the 3 councils, then that's a different matter. Don't just give us a table of figures. Yes, you can put up your hand and wait for a second round and give you 1 minute. I think that from the figures, the conclusion that we can draw today is that it is unreasonable to suggest that there is no abuse of legal aid at all. Mr. Paul Chair, I need to declare first of all that my firm also takes up legal aid cases. I think there is something hidden in the figures, because there are basically 2 categories of figures. For JR cases, there are certificates relating to refoulement claims and JR cases other than non-refoulement claims, but this covers a very wide scope. If we're talking about individual legal aid applicants involving decisions made by the government and that the individual's interest is affected and that he is an aggrieved subject, then that's one kind of JR cases. However, there are also another kind of JR cases that attracts much publicity. It may not involve the interest of an individual, but the applicant may be very passionate about current affairs, and the applicant may be very concerned about some social issues, and because of the minimal costs involved, the applicant may decide to file a judicial review against the government. And these are 2 different scenarios. In the first scenario, there is an aggrieved subject. In the second scenario, however, the applicant is only speaking out for the public in general. So do you have a breakdown of these cases? Because it is crucial to decide whether it's a case of abuse. And the recent and I've also heard about the director's decision to invoke Regulation 11 to put the applicant on the blacklist, so to speak. I want to know in the previous 3 years how many such persons have been put on the blacklist and for how long, and whether a period of 3 years is too harsh, whether it is the maximum period. If you can't provide the figures now, please do so later. Director, thank you, Mr. Chair, for your questions. Responding to your first question, the criteria for approving legal aid applications are that we do not distinguish between the points that you suggest. The criteria is the criteria are based on the merits test. That is whether there is any locus. If there is no locus, no legal aid will be approved. Well, we all understand the point about locus. Sorry to interject, but I need to ask a more specific question. Let's say air pollution to an individual who is suffering from asthma, and if in his neighborhood there is air pollution, or that someone has failed to meet the legal requirements, whether in that case is there a locus or not? I'd like to have your view and see whether you can be more stringent about that. In JR cases, first of all, we refer to past judgments, and if there is no judgment, we will seek independent advice from the independent counsel. The crucial factor is whether leave has been granted. If there is not even sufficient grounds for the court to grant leave, then we will not approve the legal aid applications. Do you have the figures at hand? Yes. In the past 3 years, in 2016, we made 28 orders under Regulation 11. In 2015, 25 orders. 2014, 43 cases. The length of the period, 3 years for all the cases. I'll queue up for a second round. Next, Mr. Junius Ho. Who else would like to speak for the second round? Dr. Elizabeth Quat. 3 minutes at most. First, I'd like to follow up on this point about the system. Director, you mentioned that in considering the application, you would seek advice from independent counsel. Can you give us some figures? The cases involving legal advice from independent counsel and the firms involved. We want to know whether the arrangements is fair. And in seeking legal advice from an independent counsel, is it done by discretion, or is it that whenever a JR case appears, you would approach an independent counsel because he is the expert? Because it's a point about the system. We want to have a fair system. The applicant is not just a locus. It must also be a meritorious case for leave to be granted. We're all familiar with this. But the point is, we do not have the figures. If you seek advice from independent counsel, then maybe the application will be approved in one case but not in the other, despite the fact that the applicants may come from the same background. They're all middle class. And there is also another comment. And that the decision should not be made solely by one barrister. There should be a roster. And because we all have friends in the circle. And for seeking legal advice, you can seek advice from any barrister, not necessarily somebody who charges astronomically. And after seeking legal advice from an independent counsel, you also need to make your own decision. And for solicitors and barristers, well, although he may be somebody you're really familiar with, you cannot allow a choice of lawyers, that it should be strict adherence to the roster, in all fairness. And for the legal aid fees, I don't think that the price should be seasonal. Because if one counsel follows through a big case, the sum could be astronomical. And also for independent counsel, in the arena of public law, we want to know whether you're always engaging the same independent counsels for the sake of fairness. Next, Mr. Junis Ho. Thank you, Madam Chair. JR cases accounted for 5% of the total legal aid costs. I think that the government is being very generous. This sum is already astronomical. 7,000 odd cases of civil legal aid and 2,000 odd criminal legal aid cases. Altogether, 9,000 or 10,000 cases of legal aid approved per year. The director referred to the table, citing figures in 2014, 15. Well, although the figures don't directly show the actual cost, we can have a clue because it involves about 100 JR cases. Let's say of 10,000 cases per year, you approve 100 cases in relation to JR cases. Well, that's 120 to 150 cases per year. That accounts for only 1% of the total legal aid cases. But if we need to foot the bill by up to 5% of the total legal aid costs, that's really substantial. So I need to pick up on Dr. Quad's point. We have done something really good, and we should not be blamed for being irresponsible, because the 1% took up 5% of the total legal aid costs. So I think that this is a substantial sum, and we're already favoring JR cases. And I'm referring to the table in heading B of Annex B about case allocation. Whether it should be some 20 or 30 cases, as pointed out by Madam Chair, the table is misleading. You can't only judge by reading the number of cases in this table how much is being charged by the firm or by the council, because on average a JRK costs $300,000 or $400,000. If you assign over 20 cases to one firm, then you are really favoring that firm. So I want to ask about this assignment system. Apart from the number of hours, can your department also monitor the costs involved? Because 5 JR cases may exceed a certain assignment limit, and that's my preliminary view. I think that the legal aid department has been very generous. You allocate 5% of the total legal aid costs on 1% of the total legal aid cases. There should be a fairer distribution of resources. I need to draw a line here. Next, Dr. Elizabeth Quad. This paper seeks to allay the public's concerns as to whether there is any abuse of legal aid. We cannot suggest that there is an abuse of legal aid, but that it may not be as serious as some suggest. And there is a concern of favoritism. For example, some lawyers may encourage the public to apply for legal aid and to nominate those lawyers as their counsel after obtaining legal aid. And Dr. Priscilla Leung just now asked whether you want to revamp the system to allay the public's concern on legal aid. Director, and yes. Well, I hope I have the chance to answer all the questions. But you'll be using up all my time to answer the questions of all members. All right, I'll give you time to give your conclusion later.
Please answer Ms. Kwok's question first. Please give him back the time. Thank you. 2 years ago, we have put in place a declaration system requiring the applicant, in the case of nomination made, to declare that there is no sharing of interests or anything with the nominated lawyer or the staff members. And we have incorporated a condition in the assignment that there should not be any conflict of interest. We also require an acknowledgement that if there is conflict of interest, say for example, encourage the person to apply for legal aid and to have himself or herself nominated, then there needs to be a declaration. It's a condition in the assignment. I would like to ask a few more things. Well, you say that there should be a statement saying that there is no sharing. I wasn't talking about that. I said someone asked a person to take out litigation and apply for legal aid and then to nominate that person as the lawyer. So there is no sharing whatsoever. So your system fails to address that. In relation to conflict of interest, are there any written guidelines? Well, I am not pointing my finger at any political party, but if there is a member of a political party targeting the government or funding application, then the political party encourage a member of the public to take out judicial review cases to hinder government projects. Then is there any conflict of interest? There is a report system in our department. It's difficult for me to tell whether there is any conflict of interest in vacuum. Well, one may furnish us with information making a report that there is abuse, then we will conduct the investigation. And if it's substantiated, we will impose disciplinary sanction. Any standard when it comes to the conflict of interest? That is a very important point. Under the legal aid ordinance, the most important thing is to act in the interest of the aided person. Well, conflict of interest may not be monetary. It can be political. So I asked the legal aid department to seriously consider that. Well, I will give the director 3 minutes and Mr. Peary 3 minutes to give a succinct concluding remark. Director, please. I would like to answer your question about seeking advice from an independent counsel. In 2016, we have sought advice in relation to 103 cases involving 63 counsels. I don't just want 2016. 2015, 99 cases and 50 cases. 2014, 90 cases and 45 counsels or barristers. So each barrister will take about 2 cases. Sorry, you have made the same mistake. You give me figures only, and I was talking about area. Public law, are they always the same ones? Civil, are they civil law? Are they the same lawyers? The figures you've just given me are of no reference value. I need a breakdown. Do you only approach the same people in the same area? I want to know whether there is a fair distribution. We need to address the systemic problem. Yes, I could give you the information after the meeting. Anything else? Mr. Peary.
Yes, I want to support what Mr. Kong is doing. The first point is that the government gave an undertaking, I think in 2001, to give legal aid an unlimited budget. And that has always been the case since legal aid was started in the late 1960s. Secondly, I think that Mr. Ho probably missed, Junius Ho probably missed the point that the there's an upsurge in these JR cases because the Director of Immigration was not processing the applications for dealing with illegal immigrants. And that has consumed a lot of time and expense. And of course, just after the handover, there were also a large number of cases involving people's right of abode and right to come to Hong Kong and their children. So this is, using Madam Chair's words, a seasonal approach. This is what happens. So at the moment, those cases are going through, and I think it would be quite wrong for the Legal Aid Department to be forced to give information to the public about why a particular application was granted and why it was refused, because there are personal aspects of each case. And I think the great advantage of our current legal aid system is it's run confidentially. And I would urge those that want to sort of pick open the file to not to do that, because it's a confidential system, and the appeals are confidential too, so that people's private affairs are not the subject of public scrutiny. And I think one has to ask the Chairman and the Legislative Council to strike a balance for everybody's interests, to see that it's a very fair system and that there is not nitpicking just over a few cases. I think the other thing which Mr. Kwong ought to be congratulated for is the high success rate in these judicial review cases. And they may cost more to run as compared with a divorce or a simple contract claim or a running down action, but that's the fact of those case lives, and you can't just pick out judicial review as being an unfair high cost bit of litigation, because those are of necessity what the costs are involved. If you look at the submissions in these cases, they don't take just days to do, they take weeks to do, and the papers are, just the submissions themselves are inches thick. And if we want proper people to be properly represented and have their rights tested properly under the one country, two systems, this is most important, because if you're in the Legislative Council, I'm just going to Legislative Council saying something and speaking your mind. You don't want your mum or dad arrested somewhere else in another place for you just speaking your mind in this chamber. So these rights are very, very important at this point in time, and I do commend Mr. Kwong for spending time and effort on them. And it isn't a detraction from other cases. Specialist officers deal with these cases. They're not going to be moved across to personal injuries or contract claims.
Sorry.
So I just want to complete my sentence. Yeah. You can't just switch resources from one type of officer handling one type of claim to another, and I think it's fallacious to do that. Yeah. Thank you.
Yeah, I think, thank you for your opinion and attendance of this meeting, but I have to let Mr. Piri also know, Legislative Council, when we handle public fund, we have to require public scrutiny. And legal aid has occupied a lot of public resources. This is our role. This judicial committee is not only looking at the interests of the legal profession, but also public interests. So to deal with confidentiality, you can always put the name off. Okay, you do not need to give us the names and the particular case. But I think Ms. Kwok's request is to get the reasons, the grounds, why they approve the funding. I have no objection at all, even to expand the funding of legal aid. That's why from the very beginning we said we do not need to have any cap. But the distribution of cases, not only for judicial review, I think some of them are very interested in judicial review, but some other cases we are interested in, like civil cases, and we said that also disputes for individual and the IO, etc. So we have to review the legal aid system not only from a very narrow perspective, but we do need to have public scrutiny. So Legislative Council is to supervise how the public money is spent. So we would like to get how you actually allocate those fundings. I think those questions within this committee we have to discuss and you have to follow. Okay? But in terms of whether the cases should be kept confidential, they can be kept confidential all the time, okay? But not like this. Give us just how many cases, okay? We need to know how many percentage of the resources have you spent on one case, and whether they concentrate on some particular law firms or some particular individuals, and that is also a lot of letters sent to us. They would like us to discuss from different solicitors and councils also. So thank you very much, but I think we are requesting for more information. I can't allow any discussion in this regard. You can submit your additional information to our panel later in writing, okay?
援助嘅範圍問題呢，我都想，如果你唔介意，我好。
If you don't mind, I would quickly. Sorry, I can't. You should have said it before. You can give us written as information paper. Next, we invite the Home Affairs Bureau to talk to us about provision of legal advice services for persons detained in police stations. Paper number CP bracket 41386/16 to 17 bracket 05 is the HAB's paper on legal aid services, Council's proposals on the provision of legal advice services for persons detained in police stations. I'll first ask Mr. Patrick Lee, the Deputy Secretary, to present the paper. I also then will ask Mr. Graham Harris to speak. He's from the Bar Association. Thank you. The Legal Aid Services Council has conducted a survey. They have given us some recommendations. In November 2009, for background information, the Council's embarked on a study on whether legal assistance should be extended to cover persons detained by law enforcement agencies. When conducting the study, the Council met with the two legal professional bodies, the Legal Aid Department, Duty Lawyer Service, and law enforcement agencies. The Council also carried out a comparative study in other jurisdictions. Well, we have looked into the issue. The Council proposed publicly funded scheme to give legal advice to persons being detained. It should be run on a pilot basis subject to review. The Council is of the view that as a start, there can be 4 police stations identified under the pilot scheme for no more than 2 years. There should be an interim review after the first year and a comprehensive review after the second year. You'll find the detailed information in paragraph 5. The Council also considered whether to incorporate this scheme under the Council's legal aid service. However, it's not pertinent to the scope. And on top of that, conducting means test when there is an urgency of the nature of this kind of cases is not feasible. So using a publicly funded scheme is better. There will be a significant impact on operational and financial implications. The issue should be carefully examined. We will be happy to take into account the points raised by members now.
So I'll now invite representatives of the Hong Kong Bar Association, Mr. Graham Harris, to speak.
Madam Chairman, we warmly welcome this pilot scheme. the time between an initial arrest and a charge or a release on bail can be a very important time for a person who is a suspect. He might need advice on whether or not he should exercise his right to silence, whether he should cooperate, whether he should provide information, and for him to be able to do that with the benefit and advantage of proper legal advice has to be a good thing and in the public interest. We don't really have any other comments to make. We welcome the programme and we look forward to seeing it implemented.
Okay. Thank you, Mr. Harris.
Questions from members, please, Mr. Holden Chow. Thank you, Madam Chair. For access to legal advice by detainees, we of course agree that they should be provided with legal advice. We must safeguard our legal system, but I have a number of questions about this pilot scheme. I'd like to clarify a few points. Does it mean that, well, at the moment, 4 police stations will be covered in this pilot scheme, but does it mean that in the future it will be extended to all police stations, such that for the legal profession, arrangements will have to be made so that our legal professionals can provide the service round the clock? I'd like to have information on this. And also about the legal advice available, because the detail is not set out in the paper. Well, if the legal advice is only about whether the suspect should remain silent, then that's simpler. Whereas, if there are other issues, whether the legal representatives should accompany the suspect in the taking of statements, then according to the paper, the lawyer providing the service should not be kept there for more than an hour. Well, in our real-life experience, just for the making of statements, very easily it would take far more than 1 hour. It would be up to 2 to 3 hours. And also, talking from experience, when you arrive at the police station, you may not be sure about the location of the suspect or the detainee. And on telephone advice service, now according to the paper, a call center will have to be set up. So that goes back to my previous question. Does it mean that we need to arrange for lawyers to be duty lawyers round the clock to take questions? So I'd like to have your replies on these questions. Yes, thank you, Madam Chair. Thank you, Mr. Chow, for the questions. As I mentioned just now, this is a recommendation from the LASC, and they would like to implement the pilot scheme on 4 police stations so that we have a publicly funded scheme. And Mr. Chow referred to some very good points, whether service has to be provided around the clock and where should the center be set up. Details are yet to be ironed out by the administration. There may be some operational issues. There may be financial implications. Basically, the LASC's recommendation is set out in a paper. As for the details, we'll need to rely on the work of the internal work of the department. And even if the pilot scheme is to be implemented, there will be an interim review after implementation, after the first year, and a comprehensive review after the second year. So when we deliberate on the proposal internally, we'll definitely consider Mr. Chow's views. Mr. Holden Chow, just to supplement, Madam Chair, I think that we need a more detailed assessment We need more information because it involves quite a substantial change. We'd like to have more details. Right, next, Mr. Alvin Young. Thank you, Madam Chair. We think that this scheme is very much welcome. We have been striving for this scheme for many years. Once a person enters into proceedings where legal advice may be necessary, this pilot scheme would help the person seek justice. Now, for the 4 police stations covered in the pilot scheme, I'd like to know the criteria for choosing the police stations. Is it because these police stations deal with the largest amount of cases, or is there another reason? Yes. Thank you, Mr. Young, for your question. I'm sorry to say that we don't have the details yet, because we would like to seek members' views at this early stage before we start our internal deliberation. We need to iron out the details soon, and we'll be happy to take views from members. But before we understand the position of the administration, in short, if the police stations are chosen based on the number of arrests made, I think that we need to have further discussions. The other point is about paragraph 5D. The service should be extended only to persons where bail is refused by the police or where the detainee cannot afford the bail money. On this point, I'd like to say that because very often during the initial stage of a criminal case, we may not know whether the arrestee would be released on bail. Very often it will be towards the end of the police procedure that the bail matter would be decided. Let's say if I arrest someone, you may imagine that the person would be told whether he would be released on bail. But from our experience, in a criminal case, you need to go through a whole set of procedures, including the taking of statements, before eventually the OC case decides whether to release that person on bail. So I'd like to have your view on this matter, and also I'd like to know the policy reason why there is a differentiation between persons getting the service, so that only persons not getting bail would be eligible. I think the LASC's recommendation, in principle, is that if the person's liberty is restricted, then legal advice should be accessible to that person. So on this understanding, where a person is refused bail by the police or where the detainee cannot afford the bail money, this person's liberty will continue to be restricted. On the other hand, if the person is released on bail, the person is at liberty, and therefore the relevant pilot scheme should not be extended to cover these persons. But I emphasize that this is the LASC's recommendation. For details, we need further deliberation and consideration. Madam Chair, then my comment is this. If the rationale is to provide assistance to those losing liberty, it may be too late. Originally, the idea is to provide legal service at the police station so that the arrestee would know his rights, and at the time when the statement is taken, the person will have full knowledge of the legal protection available to him. We're talking about early intervention and assistance, instead of pushing it to the later stage when the person it's decided whether he can be released on bail or not. And I also like to declare that I am a barrister. I take criminal cases. All right, next member, Dr. Elizabeth Quat. Thank you, Madam Chair. This is a major proposal with far-reaching implications. The paper itself is simple, but I'd like to know more details. Have you assessed the number of detainees in a year, and how much cost would be entailed in implementing the scheme? Thank you, Madam Chair. Thank you, Dr. Quad, for your question. As I mentioned just now, this is the LASC's recommendations, and we'd like to take this platform to seek views from members. And members are correct in pointing out all the details that should be considered. For example, whether there should be a cap, whether service round the clock is needed. All these will have major resource implications on the part of the government, and if we are to roll out the scheme in full, we need to consider the implications. The point is, we'd like to seek members' views at this early stage before we deliberate and finalize the proposals. That means this is just a concept, you don't have any details. But let's say there are comments that the time limit should be restricted to roughly 1 hour. I am not a lawyer, but very often I assist the members of the public in reporting matters to police. And the last occasion, I accompanied a person to the police station for a domestic violence case, and the mother spent 4 hours in making a statement. So I would like to know the rationale for proposing a 1 hour limit, because for me it is not logical. It is really not in touch with the reality. I mean, who has come up with this suggestion? Why is it in the paper? Paragraph 5B refers to the consideration of the LASC in drawing up this recommendation. The mainstream view, the majority view, was that the service should be provided to a detainee for not more than 1 hour. But it is not really a decision or a conclusion. Well, but what about service lasting for more than 1 hour? What should we do? Well, it also states that under special circumstances, the lawyers may extend the service hour. So it's pointless to suggest that the service hour should not last for more than 1 hour. Second question, has the LASC consulted the relevant law enforcement agencies, for example, to understand the general operation in police stations? I understand that the LASC has consulted law enforcement agencies, and yet the 1 hour time limit is still included in their recommendation. I find this absurd. I think there is too little information contained in the paper, and the proposal has far-reaching resource implications. I think the administration should consider very carefully. Second round, Mr. Junius Ho for the first round. Madam Chair, I'm not against this proposal because, as in the previous item, for legal aid service in Hong Kong, the government doesn't set a limit for the sake of safeguarding human rights. But I have a suggestion for Mr. Lee's consideration. In general, legal aid is only available for cases in district court or above, and the duty lawyer service scheme, however, covers all cases in the magistracy. The total budget annually is $100 million, including administrative costs, and for legal aid, however, the budget is one of $700 million. So that's the proportion. And then the LASC all of a sudden suggests that they can take up more work. Well, I'm not against that for the sake of safeguarding human rights. However, if the legal aid accept cases of detainees in police stations, is there a disconnect here? Because for district court or above, these litigants are eligible for legal aid, whereas for detainees who have yet to enter legal proceedings, who have yet been charged, if this is also taken up by the legal aid, I don't think it is desirable. I think that the duty lawyer scheme instead should take up this work.
Because it may be more logical. 2. I see that your preliminary suggestion is that the service won't be available once a person is charged. It's only available for people who are detained or for some reason not granted bail. So waiting time can easily exceed 1 hour. So I have to wait for at least 30 minutes. Is it included? You also talk about a contribution ranging from 500 to 1,000. I don't oppose to that. But a lot of these people don't actually have money. Say, for example, overstayers. Well, the Law Society gives them 45-minute free legal advice service covering over 100 law firms. Very often I receive these calls, but I am never available because they never call at the right convenient time. They mostly call in the middle of the night. So what incentive do you give to people who participate in the scheme because they have to give up their personal time? I support it. But how much money do you put into it? Who is going to run it? The duty lawyer scheme, wouldn't it be better? Would you give $30 million out of the 100 million to run the scheme? Yes. I thank Mr. Ho for his view. We will take that into account. Second round, Mr. Alvin Young, 3 minutes. I was going to suggest what Mr. Ho said. Majority of criminal cases are dealt with in Magistrates court. Well, I'm talking about forms used in duty lawyer service. If they use the same system, same forms, it will save a lot of paperwork. Well, whether you duty lawyer on the duty lawyers list or legal aid list, you have to make yourself available. I do think that well, there will be more lawyers on the duty lawyer list to do it because they have more experience. Any response from the administration? I thank Mr. Young's comments, and I will take that into consideration. Members have also asked questions about whether 1 hour is sufficient. It easily takes you 3 hours. Is about this topic, Mr. Holden Chow. Thank you. Just one more question. When it comes to actual operation, what are the arrangements inside a police station? Say, for example, rooms available. Do they need to change anything? What the call center is one arrangement. Face-to-face interview. There may be many people detained who require this kind of service, and you will have to make available rooms. Previously, these people have to make arrangements themselves, and with this service, I'm sure a lot more people will use the service. So can there be rooms made available in the police station? Would you take that into consideration, or have you already talked to the police? Yes. Just briefly, and I'll see if the Security Bureau needs to supplement. It depends on the scheme, should it's decided to proceed. If they need separate rooms, is it necessary to make changes in the police station? That will be an operation level, and that will have implications on the finances as well. That's why I said at the outset, we have to look into this issue very carefully. Yes. I would like to supplement. Mr. Chow's question is valid. When law enforcement agencies are involved in the discussion, well, since we all thought that since it is a free service and there is no screening involved, so a lot of people will want to use it. It will have an implication or demand on translators, interpreters, rooms, whether there is sufficient lawyers available, whether it will prolong the detention period. So we have to carefully go through all these issues. Thank you. If there are no other comments, this item comes to a close. Thank you. We can follow this up outside the meeting, and I'm sure the Bureau would like to continue to follow this up with us. Last item, the rule of law and the role of the prosecutor. Paper CB bracket 41386/16 to 17 bracket 06 is the administration's paper on the rule of law and the role of the prosecutor. There is also another paper, bracket 07 is the background brief prepared by the Secretariat. First of all, I would like to ask Deputy Director of Public Prosecutions, Mr. Martin Hui, SC, to take us through the paper.
And we also have representative of the Bar Association, Mr. Graham Harris, and also Mr. P.Y. Low. Mr. Hui, please. The role of law and the role of the prosecutor. This is in response to members concerned about work of prosecution of the Department of Justice. It is not appropriate for us to comment on the individual cases, but I would like to briefly talk about important principle of the rule of law and the role of the prosecutor in upholding this important principle, so that members will get a better understanding about policy and procedures involved in initiating prosecution. I would like to first present the paper, and then I'll be happy to answer questions. First, the rule of law. Criminal justice system is one of the most important aspects of our legal system. It underpins the rule of law. Independent prosecution is a very important element in this system. Article 63 of the Basic Law provides that the Department of Justice of the Hong Kong SAR shall control criminal prosecutions free from any interference. When we handle prosecutions, it will be done in accordance with the law, standard practices and policies, independently without being influenced by any other considerations. In relation to our standard practices and policies, there is a prosecution code. When decisions are made to prosecute, the laws will be taken into account, the prosecution code will be abided by, and all factors will be taken into consideration. We will also ensure a fair trial and to ensure that all parties are treated fairly. The code is a statement and
and a set of directions, which clearly sets out the policy and procedure in relation to prosecution, so that officers can follow these procedures. Basic principle is to uphold the rule of law. The code clearly sets out that when investigation report is given by law enforcement agencies, how a prosecutor should give a legal opinion and all the procedures to be adopted. And I would like to point out a number of salient points. First, the independence of the prosecutor. The code states that there is an important role of prosecutors as independent ministers of justice who works fairly and dispassionately. You'll find the detailed information in paragraph 7 in relation to the role and the principles in place. Another point, division of labor between the prosecutor and law enforcement agencies. Law enforcement agencies in Hong Kong are responsible for criminal investigation. The Department of Justice is responsible for giving legal advice to policy bureaus and departments, and is also responsible for criminal prosecution. The Department of Justice does not have any power to conduct criminal investigation. Under appropriate circumstances, the prosecution may ask for further investigation to be conducted, but they may not direct how investigations are to be conducted. The prosecutor will act in accordance with the prosecution code as well as appropriate laws, and on top of that, evidence and procedures have to be taken into consideration before giving legal advice. Another part is decision to prosecute or not. First of all, the prosecution has to consider whether there is sufficient evidence in place. This is in line with other common law jurisdictions. The current principle is whether there is a reasonable prospect of conviction. If this sufficiency of evidence test is passed, then the prosecution will have to consider and balance all issues of public interest. In relation to the factors to be taken into consideration, you'll find information in paragraphs 15 and 17. On top of that, the prosecutor has the duty to continually review a prosecution. If there is a change of circumstances that result in an insufficiency of evidence, and that there is no longer a reasonable prospect of conviction, or the interest of public justice is no longer required, then the prosecution may be discontinued. You'll find a relevant chapter in the code setting out the steps to be taken in relation to prosecution, cases of interest, and information related to other parties. Members of the public may download this code from the website of the Department of Justice. If there is any question about our work, I'll be happy to elaborate. Thank you. Thank you, Mr. Hui. I'll now ask Mr. Graham Harris, representative of the Bar Association, to speak.
To the panel, thank you.
Thank you, Madam Chairman. We really don't have too much to say because, to us, there isn't much in the paper that is new. I was a prosecutor in the Department of Justice in the 80s and 90s. I think probably the only thing that is different in terms of concept is it's all now codified, and you can read it on the internet. We don't really have anything to add to what Martin Hoy has had to say, and as long as the code is kept to, we see this as not a problem.
Mr. Low? I only have a number of points to make. Members may refer to the code about the independence of the prosecutor and also the provision in the basic law in relation to independence. In the paragraph 1.2 in the code, it says that when a decision is made, the prosecutor must not be influenced by a number of factors.
And then paragraph 1.4, the Court of Appeal stated in the case, the prosecutorial independence and also the role and duties of the prosecutor under point 3.2 in relation to a Supreme Court of Canada case. It is clearly spelled out that the role and functions of the prosecutor is not just to secure a conviction, but to ensure that as far as the prosecution is concerned, all evidence are available to the court and it should be done in an impartial manner. So these are the cases for your reference. Thank you, Mr. Low. All right, I've opened the floor for members to ask questions. First, Dr. Elizabeth Quart. Thank you, Madam Chair. I also agree with Mr. Low that independence of prosecutors is the most important point. Now, I'd like to ask Mr. Low this question. Recently in the community, there have been suggestions that the administration is taking political prosecution, and that prosecution is being used as a tool for the government to oppress the opposition. So, according to Mr. Low's observation, do you agree with this suggestion, Mr. Low? Well, let me try to answer this question. Well, you may invite the administration to take that question as well, but Dr. Quart would like to have your take. Well, we have read from the news some comments made by individuals suggesting that there are problems with certain decisions to prosecute. It's easy to make these comments, and it's easy for these comments to be reported in the media. But I think that we must trust that the prosecution would abide by the prosecution code, and we also have the judiciary to ensure that the sufficient evidence has been adduced to support the prosecution in due process, and for the judiciary to make a ruling on a case. And it is also monitored by the appellate courts. So, Department of Justice, let me turn to you. What is your response to these allegations? I have another question as well. Can the Chief Executive of Hong Kong SAR request a withdrawal of prosecution for cases that the DOJ has already initiated prosecution? Can the Chief Executive order a withdrawal? Mr. Hui. Now, for colleagues in the Criminal Prosecution Division of the DOJ, we uphold the principle of impartiality and independence and fairness in dealing with each and every case. And I can tell the members and the public that there is no favoritism when it comes to prosecution, and politics are not involved in our decisions to prosecute. We work in accordance with the framework laid down in the prosecution code. We consider solely on the merits of evidence. We do not consider any political factors in deciding whether to prosecute. As to whether the chief executive could possibly influence our decision to prosecute, I can say that it is impossible, because the Department of Justice is bound by Article 63 of the Basic Law, and that there should not be any influence on the decision to prosecute, whether the decision comes from the public or from any other person. There would be no influence on our decision to prosecute. Next, Mr. Junius Ho. Madam Chair, I am strongly in support of the prosecution code. And of course, the Department of Justice also exercise independence. Apart from the principles, I'd like to ask this question. Justice delayed is justice denied. So in the event of a delay, what is the cause of the delay? We understand that the Department of Justice would, of course, handle all cases independently. But in some scenarios, when a case has not been prosecuted for 2 or 3 years and no account has been given to the public, how can we strike a balance? Because according to the prosecution code, it also refers to delay in initiating prosecution. So in your department, is there any code in this regard? Because usually you're very efficient. You may even refer to the media coverage for evidence, although you definitely would rely on the investigators' reports. Let's say it has taken 8, 12, 18 months already. How are you going to give an account? And I'm specifically referring to the Occupy Central movement. Of the 1,030 cases, only 30% of them, of the persons were prosecuted. I don't think it's efficient enough. So would Mr. Hui tell us how you reconcile the point of public interest under 5.8b? Thank you, member, for the question. It is not appropriate for us to comment on individual cases, but I can reassure Mr. Hui that every colleague in the Criminal Prosecution Division of the Department of Justice strives to consider thoroughly every case that requires a decision to be made on whether to prosecute. And Mr. Ho also mentioned a delay a justice delay is justice denied. In the common law jurisdiction, we uphold this principle. However, the complexity of the case and the nature of the case may be different. There is not a single yardstick that applies to every case, especially in relation to the time frame. I can say that when it comes to a case of major interest, we need to consider very thoroughly all the evidence and legal principles available And we also use the same code and the same yardstick in deciding whether to prosecute or not. Next, Mr. Holden Chow. We have 5 minutes left. So if everyone has another chance to speak, we'll need to spend an extra 5 to 10 minutes. So is it all right to extend the meeting? We'll extend the meeting by 15 minutes most. Mr. Holden Chow, just a brief comment about the Department of Justice and your colleagues. Prosecutorial independence and your professionalism. I have absolute faith in you. Earlier, because of participants of the Occupy movement being prosecuted, there were suggestions that these are political prosecutions. I think that this is mudslinging against the Department of Justice and your colleagues. So my comment is that in relation to our legal system and the independence and professionalism of your colleagues in the department, and that your decision to prosecute is not subject to any undue influence, I have absolute faith in you. And there is nothing in this allegation of so-called political prosecution. All right, when it comes to public law and civil law and also judicial review cases, very often you would engage counsel on fiat, whereas for criminal cases, in very recently, the criminal cases come in different nature with different merits, and you need to handle them on a case-by-case basis. So is it a common practice to engage counsel on fiat, or would your colleagues in the department handle these cases? We do engage counsel on fiat. It is necessary because for the criminal prosecution division, we have 130 plus prosecutors, which is not sufficient for processing all the cases. We therefore find the need to engage counsel on fiat. As for the nature of cases and what the types of cases to be outsourced, it depends on the complexity of cases. And of course, for cases involving major legal principles with a more complex set of facts, we also need to consider whether there is any appropriate colleague to take up the case, and these are the factors for our consideration. In the magistrates' courts every day, we come across a large quantity of cases, so on a regular basis we do engage counsel in the private practice. Well, let me ask more frankly. Let's say if you have a surge of cases coming in that cannot be handled by a single colleague, does it mean that at present you engage counsel on fiat to reduce your workload? So the counsel on fiat is engaged because of an sudden increase in number of cases, but not as regular exercise. Right, of course, if there is a sudden surge of workload within the department, our colleagues may not be able to cope with the workload, and therefore I will consider whether our colleagues are available to handle the cases based on the complexity and the nature of cases. But it's done on a case-by-case basis. Dr. Elizabeth Quat, you want a second round? Thank you, Madam Chair. To pick up on my last question, I'd like to ask the Deputy Director this question. Well, if somebody suggests that the Department of Justice must not prosecute certain suspects, then would he be perverting the course of justice?
We need to study the details of each case. The basic legal principle is that when we make a decision of prosecution, we have to consider first whether there is sufficient evidence, whether these evidence will give us a reasonable prospect of conviction, and then we will decide whether there is a balance of issues related to public interest, and then we will decide whether to prosecute or not. There is no such thing that we will ignore reasons, factors, and details when we receive a request not to prosecute. It is an independent decision. We are not under any influence of factors that I have not outlined. Ms. Quat, some people, even people from the legal sector, have been saying that the government has been using prosecution as a political tool to it's actually political prosecution, and they even say that the recent disqualification case is one of them. Would that affect your decision, Mr. Hui? Judicial independence and prosecutorial independence are very important. Different groups and different people may have different opinions. When we deal with each case, the most important thing is to maintain independence of prosecution and independence of the court. Now, these are two important elements in the rule of law. All questions have been asked. Mr. Ho, you have answered a lot of questions. I'll see if you would like to supplement anything. And Mr. Harris and Mr. Low, would you like to say anything? Nothing, thank you. Mr. Ho, I thank you very much for staying with us till 7:33. This is the last meeting of this year. Thank you. I wish you all a wonderful summer holiday. Thank you very much.